We're back to give you the legal edge. A third of all doctors will be sued for medical malpractice sometime during their careers. But what is malpractice and how do you demonstrate it in court? Here's local attorney Brian Waldman to explain.
A medical malpractice claim is simply a claim that asserts that a healthcare professional was negligent and that negligence caused an injury to a patient. They include things like failure to make a diagnosis, maybe a misdiagnosis was made, or an improper diagnosis was made, or a surgical error was made. In order to prevail on those types of claims, a patient has to show that the healthcare professional breached the standard of care. What does that mean? Breaching the standard of care means not behaving the way that a healthcare professional would in the same or similar circumstances. And then beyond that, that breach of the standard of care has to result in an injury. It's not enough that there's simply a bad outcome. It's not enough that someone sustains an injury. For example, almost all medical procedures, surgeries involve certain risks. And if the bad outcome or the injury that comes at the end of the surgery is a known risk of the procedure, then the doctor is not responsible for the harm. It's only if their breach of the standard of care resulted in the injury that the patient will prevail in a medical malpractice claim. And if the patient is able to show a breach of standard of care that did result in injury, what the law calls a proximate cause of the injury, then they'll be entitled to damages, economic damages, which include medical bills and work loss or wage loss, and then also non-economic damages, which include things like pain and suffering and change in lifestyle.